Good morning.
Morning.
Okay, I have three matters on my calendar this morning. And I'm just gonna get in and figure out who all is here for those matters first, and then we'll figure out what to do with them. First up, I have Stacy Robinson versus Caleb Walton. Who do I have here on behalf of Stacy Robinson?
Melinda Holloway for the plaintiff.
Thank you, Ms. Holloway. And who do I have on behalf of the defendant, Caleb Walton?
Melissa Alayus and Amari Marable.
Okay. Thank you. And then I have Bank of America versus Tracy Smart. Who do I have here on behalf of Bank of America?
Andrew Melhorn, Your Honor.
And Tracy Smart as defendant.
Oh, thank you. Sorry, I was looking down when you first spoke, so I didn't see who was talking.
Oh, yeah.
Thank you. Okay. And then I have Jeffrey Moore and Casey Moore versus Ed and Melanie King. Who do I have here on behalf of the Moores?
Matthew Carlton.
Hi, Mr. Carlton.
Good morning. How are you today?
I'm doing fine, thank you.
Then Jeff and Casey Moore.
Thank you, sir. Mr. and Mrs. Moore. And then who do I have here on behalf of Mr. and Mrs. King?
Good morning, Your Honor. It's Leanne Jones on
Hi,
behalf
Ms.
of Mr. and
Jones.
Mrs. King. Hi.
How are you?
Just fine. How about you, Your Honor?
Doing well, thank you. And is this Mr. and Mrs. King?
It is.
Okay.
Yes, it is, Your Honor.
King sitting at the computer of my law partner, Michael Johnson. So that's the.
Okay. Thank you. So that matter was the one that I had expected would take I mean, I don't think it'll take forever, but I think it was going to take the most time for me this morning. And so at 9 o'clock, what I'm guessing is y'all are welcome to turn off your video, turn off your audio, and I'm guessing that I will be fully ready to get to you by 9:30. Could be a tiny bit earlier, could be a tiny bit later, but that's about my guess is about 9:30. So you guys can stand down until then, and I'm going to work through these other two matters, and then you will have my undivided attention. Do you have a court reporter for any of these matters? I see a court reporter on, or two actually.
We have a court reporter, Your Honor, for the Kings.
Okay, and do we have a court reporter for anything else?
I have a court reporter, Your Honor, for the plaintiff for Stacy Robinson.
Okay.
And I'm also here for the Moore case as well.
Okay, excellent.
Thank you, Andrew.
We'll share and take down.
Thanks,
Excellent.
Matthew.
Yeah.
Court reporters like to hear that. So again, anyone that's here for the Moore and versus King matter, like I said, if you want to stand down until about 9:30, I promise I'll come back and get to you then. And then I'm going to circle back with that announcement to Stacy Robinson versus Caleb Walton. And Ms. Holloway, you indicated you had a court reporter. Is that correct?
Yes, Your Honor, I do.
Okay. So I'm going to call that case cleanly for the court reporter's benefit. This is going to be a hearing in the matter of Stacy Robinson versus Caleb Walton. The case number is 25 CV 013983. I'll note for the record that this matter is occurring entirely by video. And also just for everybody's benefit, this is being live streamed, only so that I can satisfy my obligation to have open courts. Do want to be clear though that you do have a court reporter and that this recording is an artifact of how the technology works and it is not a court document or a court record of any kind. So just want to remind everybody of that. So just before we went on the record, I got announcements from Ms. Holloway, and did you say Ms. Alius? Did I pronounce that correctly?
Yes, Your Honor.
Oh, thank you. So here's what I understand this case that we are here on. We're here on a motion for fees under 915-14 filed on behalf of Caleb Walton. The underlying suit, I did have a chance to review it last night just to sort of save y'all a little bit of time. I mean, I'm aware that this was a personal injury action originally, I think resulting from a car accident some time ago, and that Mr. Walton was the alleged tortfeasor. Ms. Robinson sued Mr. Walton and then was not able to secure service here in the state of Georgia, and then attempted to secure service in, I think, Massachusetts, but I might not be remembering that correctly. And then the matter was voluntarily dismissed and then filed as a renewal action, at which point Mr. Walton asserted that the service in the original action in Massachusetts had not been statutorily, legally sufficient under either or both Massachusetts and Georgia law. And as a result, the court determined that it was not a proper renewal action, and therefore the action was due to be dismissed and could not proceed. Now, I believe, I don't think, I'm trying to pull up my system as I'm talking, but I don't believe there's any dispute that the 9/15/14 motion was filed timely in terms of within the time period after a judgment. But if I'm wrong on that, I'm sure Ms. Holloway will tell me. Beyond that, I will say that as I understand it, the entire basis for the 9/15/14 motion is the argument that because service was invalid in the original action, the plaintiff should have known that the case couldn't be renewed, and therefore the costs associated with the renewal action are subject to sanction. Is that roughly accurate from your position, Ms. Alius?
Yes, it's roughly accurate. The only thing that I would add is that the plaintiff knew that the service was improper during the pendency of the original action because plaintiff attempted to serve the defendant 2 days after dismissal. So well before plaintiff attempted the renewal action, she knew that the service in the underlying action never occurred and was never perfected. And it's on that basis, and plaintiff admitted to the same in her response to our motion for attorney's fees, that we brought this motion.
Okay. So the reason I sort of laid out what I think are the issues is just because, one, I did my homework. So see, I promise you didn't show up with a judge who doesn't know doesn't know why you're here. But also so that I can, if I've got anything wrong or you think that you need, if something that I'm saying is incomplete to the record as you believe it exists, and I want to sort of give you direction. I think it also saves time sometimes. That way you don't have to educate me as much. And so with that, typically what I would do is sort of throw it over to you, Ms. Alius, to say, look, this is our motion. And then I would let Ms. Holloway respond. And then because it's your motion, Ms. Alius, I would let you have the last word. Is there anything else you would like to add regarding your client's motion, Ms. Alius?
I think that just in addition to what I stated before, if the plaintiff admitted in her response to our motion for attorney's fees that she knew she could not contest our motion to dismiss because she could not prove that she properly served the defendant in the underlying action and that service was proper at the Atlanta address. I think that in itself shows that if you can't stand by the service that you then renewed this action on, that the renewal action was never proper and Caleb Walton should have never incurred those attorney's fees. And that's why.
Sorry,
I'm sorry?
what is the total amount of the fees that are being sought by Mr. Walton?
At this time, the total amount is $20,760.22.
And is that sort of the all-in from the date of the refiling to now, or to the
Yes.
dismissal anyway?
That's all in from the date of the refiling until I believe the end of March, to include the preparation of the motion for attorney's fees and the hearing that was reset.
Okay, thank you, Ms. Alius. As I said, I'm going to hear from Ms. Holloway now, and then because it's your motion, I would give you an opportunity to briefly respond. But for now, I'm going to ask Ms. Holloway, what is your response, ma'am?
Okay, Your Honor, this is a case I was hired to represent Ms. Robinson on. The defendant paid their policy limits of $250,000, which shows that the case did in fact have merit. When we filed the lawsuit was filed because my client had uninsured motorist coverage with USAA. And so when we filed the lawsuit, his mother accepted service at Oak Street. I did not realize there was a problem with the initial service, an alleged problem, until the defendant filed a dismissal, a special appearance answer, and a dismissal motion with an affidavit attached stating that he lived in Massachusetts. The first people that I hired to perfect service in Massachusetts was the sheriff department, Medford Sheriff Department. I mean, it was Middlesex Sheriff Department. They didn't perfect the service until after the dismissal, which I truly regret, because I hired 3 people. When the sheriff was taking, they said that they were backed up. They were taking a lot of time. So I hired ancillary, whom I use here and in other places. Ancillary attempted service and was unsuccessful. And I also hired Mark Weinberg, who's a constable in Massachusetts, after a conversation with him. Maybe because of some mix-up, I don't think that he purposely misled me, because he is authorized to serve, but his service only up to a certain statutory limit, apparently, if he's serving outside of his area. Of course, I thought that service was perfected. Otherwise, I never would have filed the dismissal. I filed the dismissal to try to avoid a laches claim. I never would have filed the dismissal without prejudice, because the sheriff still was pending service. But the sheriff had received the papers to serve prior to me hiring ancillary and prior to me hiring Mark Weinberg. So once I dismissed the case, when I refiled it, I once again served Mr. Walton at the Oak Street address, this time personally. I had every reason to believe. In fact, I believe that the first Oak Street service was because I couldn't prove it, but I thought that he was probably attending school in Massachusetts. I thought that the Oak Street service was sufficient, but out of an abundance of caution, I went ahead and served him in Massachusetts, since they had the affidavit, and I had no way to rebut that. So when I refiled, I refiled. I did not hear from, nobody called me and said, Mark Weinberg is not authorized to serve. Had I known that, and in fact, once I did know that, that's why I did not file a response or contest the dismissal, because obviously he was authorized to serve, but only up to a certain statutory limit. Otherwise, I never would have renewed it. Everything I did was in good faith, Your Honor. Nothing I did expanded or protracted litigation to the extent that they have expended $20,000. And I think the record would bear that out. Even a cursory review of the record would bear that out. But everything
I don't know, in this economy, what lawyers cost these days, in terms of filing a motion and then and appearing for a hearing, et cetera. I mean, I will say this. If I were to award fees, I would want more information about, the nature and extent of what time was spent and what activities were undertaken. But overall, a 20,000 number didn't seem that outrageous to me for this procedural posture of the case, given that there was briefing done, et cetera. So, but please continue, Ms. Holloway.
Okay, and my understanding of the law, Your Honor, is with regards to a discretionary award of attorney's fees, that there has to be a showing that the action lacks substantial justification, or that it was substantially frivolous, groundless, or vexatious, which is not the case. The record bears that out. It either has to show that it was interposed for delay of harassment, which they have not shown any action by plaintiff other than a good faith mistake with regards to depending on Mark Weinberg, whom we paid for expedited service, by the way. There's nothing in the record to show that plaintiff has unnecessarily expanded the proceedings. Nothing to show that there was anything abusive or vexatious on the part of plaintiff.
Understood. Thank you, Ms. Holloway. Anything else before I hear from Ms. Alius?
No, Your Honor.
Okay. Ms. Alius, can you, any response that you would like to make?
Yes, so since the plaintiff opened the door to talk about the pre-suit policy limits tender that was made, that tender was made on the basis that the demand wasn't received by our office in time to respond to the demand. I think
Well, let me save you some time, Ms. Alius. I don't know how any more plainly I could say I don't care, right? It's
Okay.
completely irrelevant to any consideration that I might make in the procedural posture of this case. I'm certain Ms. Holloway pointed it out to make an argument that there was merit to the claims. I'm certain that you have a response to why your, client made a calculated decision to make a payment, et cetera. Don't care. Doesn't matter. It's not relevant to the outcome of this case. Go ahead.
Okay. And then on that basis, the pre-suit tender doesn't show that there might have been issues with the service, whether we tendered before a complaint was ever filed. Plaintiff also mentioned that the mother accepted service. The mother had no right to accept service on behalf of Caleb Walton. At the time, service was.
Let me save you some trouble. I've already ruled on that motion, right?
Okay.
That's why the case got dismissed, because I agreed with you, with your client, Ms. Alius, that that service wasn't technically proper on the mother, and that it was apparently also not technically proper through the service in Massachusetts. So.
Okay, then just to wrap up my argument here, on the Oak Street address service in this case, the affidavit did state that the defendant was only in Atlanta for homecoming, so it makes no showing as to whether or not either Oak Street service was proper. And lastly, Constable Weisberg was not authorized to perfect service in this matter, not only monetarily wise, but also geographically. We have emails with that city that state that he was never authorized to perfect service in that city. And it's the burden's on the plaintiff after we show that service wasn't proper to prove that service was proper. And I just don't think that they've made that showing. I think that the expansion of the litigation then comes when we pointed out through our original motion, we were never given an opportunity to point out the Weisberg service was improper on the prior action because the case was dismissed, I think, an hour after that affidavit of service was filed. And so when this case was renewed, we filed our motion to dismiss on the same.
Okay. Thank you, Ms. Alius. So 915-14A or 915-14 has two options. A is, this idea that the claim completely lacked any justiciable issue of law or fact that it could be reasonably believed that a court would accept the claim. And then B is sort of a little squishier, and it is a may rather than a shall. In terms of whether any of the parties acted in a way that was interposed for delay or that their actions lack substantial justification. And I'm not sure, Ms. Alius, that it is fair to us to infer that Ms. Holloway knew that the service in Massachusetts was improper from the fact that service by a law enforcement agency was made 2 days later. It's unfortunate that the dismissal occurred in the interim, because had the dismissal not occurred in the interim, then that might have been the valid service that the plaintiff needed to get service on Mr. Walton in Massachusetts for purposes of this action here in Georgia. All of this is it is an unfortunate set of circumstances, but it seems to me that while different lawyers might have chosen to not pursue it, that different judges might have not found it to be an improper renewal action. And given the circumstances, there's no way I could find under 915-14 that this position lacked completely absent any justiciable issue of law or fact. And then I don't believe Ms. Holloway may not have been informed, and she may have been the victim of an unfortunate set of circumstances. This sort of, especially with young people trying to get service when they might be, is their permanent residence their home and that sort of thing. I mean, it can be difficult, but I also think that asking for 915-14 fees under these circumstances is a bridge too far. And so I do not find that 915-14A or 915-14B damages, or I should say sanctions, attorney's fees are justified in this circumstance. And so I'm going to deny the motion that was filed by Mr. Walton. And I'm going to ask Ms. Holloway, can you please send me a very brief order that just in Word format to Mr. Freehoff, who's my staff attorney, just so I have a document to work with. So I can get an order on file for the parties, and y'all can take whatever action you'd like to take.
Okay, thank you, Your Honor.
Thank you all for your time. Have a good morning.
You too.
Okay, next up is Bank of America versus Tracy Smart. Now, in this matter,
Hello.
do you have a court reporter, Mr. Melhorn or Ms. Smart?
I
No.
do not, Your Honor. And if I may, I have a point of clarification, if I may ask.
Sure.
I have 3 hearing dates for this matter, today included. I have today. I have, let's see, bear with me, sorry. I've got it for the 7th, and I've got it for the 25th for a bench trial.
Right, that's because this case is on a hearing today for Ms. Smart's motion for summary judgment. And if the case
Okay.
survives summary judgment, your pretrial conference is on May the 7th, and then your trial date is May the 25th.
So I do not have a copy of Ms. Smart's motion for summary judgment.
So
I don't know.
Mr.
I don't
Melhorn,
know. Sorry, go ahead,
So-
Your Honor.
that's okay. So the reason we are here today is because your client did not respond to Ms. Melhorn's summary judgment motion. And everything I have in the record indicates that it was appropriately filed.
Okay.
And that your office, Mr. Freehoff could probably quote me chapter and verse on when it went out and who got notices and who opened the notices and et cetera. But the court docket indicates that Ms. Smart filed a motion for summary judgment with a supporting statement of material fact and some other documentation on February the 19th of 2026. She requested a hearing, and so we set one. And that matter was set for March the 27th. I believe the defendant requested a reset of that hearing, but for some reason it did get reset. And it got reset to today. And
Okay.
so the posture that we are in, as I said, what I was about to start with is, this is as I understand it, a fairly standard, straightforward collection action, right, Ms.?
Correct,
The
Your Honor.
allegation is that Ms. Smart had some sort of credit account with Bank of America and stopped paying, and there's some balance that is owed. Bank of America sued to recover that amount. Ms. Smart filed a timely answer, and then, as I said, filed a motion for summary judgment. Now, I have not looked significantly at the merits of the summary judgment motion because I have read it. But I have skimmed it because I was waiting for the plaintiff to respond to the summary judgment motion orally at the hearing or otherwise.
I can respond orally, Your Honor. That's fine. Based on
Okay.
her answer, based on her motions, I think I can respond without looking at it.
Okay.
I'm sure.
Well,
Ms.
I
Smart
have
would like
another
go through the
hearing to take
allegations.
up, so I can y'all can have like 30 minutes or an hour to look at those materials if you want. They're on Odyssey.
Sure, I'll look, Your Honor. That's fine.
Okay. So it is 9:30. Ms. Smart, if you will accommodate me, I do apologize, but Mr. Melhorn has. Yes, ma'am.
I'm sorry, Your Honor, I do have an appointment a little later this morning. I thought we would be on at 9 a.m.
Mhm.
And the fact that he could have gotten that information way before today. It's on file in the court and we filed it in a timely manner. I don't think that's a really good faith thing to do, to have him have opportunity after he's had a couple months. It was filed February 19th. So,
I understand.
yeah,
Can I
and
respond, Your Honor?
I wish to continue because I thought we were going to be, at 9 o'clock this morning.
Well,
And I run a business. I've got appointments I've got to go to.
as do I. I understand that. But Mr. Melhorn has exercised his obligations of candor to the court and told me that he is, he can go right now is what he said, but I don't know that it provides the court with a fulsome understanding of what the issues are unless I give Mr. Melhorn an opportunity to review it. And so that's what I'm going to do. I suspect that the hearing I am going to start in the next 3 minutes is going to take between 45 minutes and an hour, which means you guys will be back at 10:30 and then I will hear from you.
All right. Thank you.
Sounds
Thank
good,
you,
Your
Ms.
Honor. Thank
Moore.
you.
Thank you, Mr. Melhorn. Counsel for the Moore versus King matter, I'm going to go grab a fresh cup of coffee and then I will be right back and you guys will have my undivided attention. Okay. Thank you.
Thank you.
Okay. So for the benefit of the court reporter, I'm going to formally call the case. This is going to be a hearing in the matter of Jeffrey and Casey Moore versus Ed and Melanie King. The case number is 26CV001829. I have Matthew Carlton here on behalf of the Moores and Ms. Jones, Leanne Jones here on behalf of the Kings. So as I like to do, I'm going to tell you what I think I understand about your case and why we're all here today. And then when it's time for y'all to argue, you can tell me anything that I'm wrong or incomplete about. So my understanding is that the Moores initiated this action against the Kings, alleging a nuisance claim, alleging defamation or libel claim, and then seeking punitive damages and attorney's fees associated with what the Moores characterize as a campaign by the Kings, particularly Mr. King, to cause problems with a renovation that they were engaging in. These apparently they are next door neighbors. This action resulted fairly recently. I think it was just filed in February. The main reason that we're here today is because the Kings have responded with a motion seeking to dismiss this action under 911.11.1, which is the slap suit statute in Georgia that allows the Kings to argue that the claims, the underlying actions for which they are being sued are in fact protected activity that they have engaged in. This suit is an intention intended to keep them quiet rather than a legitimate legal exercise. So there's some fairly specific procedural structures we have to get through for that motion. And that's why it does have an evidentiary component. And so I wanted to ask the parties, just before we get into the full argument, what is your expectation, Ms. Jones, as the movant? What was your expectation about how this proceeding might go in terms of whether we're going to have primarily argument, we're going to have some testimony? What are your thoughts on that, Ms. Jones?
Thank you, Your Honor. And that was a good summary. We have two motions pending now. The motion to strike under 911.11.1. The motions are separate but interconnected. We also filed a motion to dismiss under Rule 12b-6, contending that the complaint fails to state a claim as to all the
which is
pending
part of that
actions.
secondary assessment if the court finds that
Exactly.
right.
If the court finds that the defendants have met their threshold burden of showing that the underlying acts on which the claims are based are protected activity, and the court gets to that second prong of the analysis, it's our position that if the court looks solely at the pleadings, as the court must do on the motion to dismiss under 911.12b-6, and rules the case should be dismissed, then really almost by definition, the plaintiffs cannot prove a likelihood of success. However, the court may also take into account, if the court says, well, they're hanging on by a slender thread on the motion to dismiss under 911.12b-6, the court still can consider whether there's a probability of success and look at the affidavits and evidence submitted by the parties. So we do think that's a little bit of a tricky situation where the court cannot consider these affidavits and evidence on the motion to dismiss because the plaintiffs have not moved to amend the complaint. Mm-hmm. So we are looking at the four corners of the document right now. All of this stuff they've submitted does not go to the 911.12b-6 motion. They have not amended. So we've got that, but those two things, and I think the court understands how they're interrelated. It's kind of my position that since both parties have submitted detailed affidavits and have submitted evidence, I don't know that testimony is going to be required. However, my clients are here. If the court has questions, if testimony is needed, we're prepared to go forward with that. But I do think the parties have fleshed things out fairly well, as a matter of fact.
Thank you, Ms. Jones. And that was my read as well. But then, obviously everybody is entitled to come and observe the proceedings. But a lot of times when there's not expected to be testimony, I don't necessarily see the parties. And when I saw both of them, I was like, okay, well, maybe they were expecting there would be maybe some more detailed testimony. Mr. Carlton, what are your thoughts on that, sir?
I would agree. We have submitted affidavits. They've submitted affidavits. I mean, you have a lot of affidavits to look at. I think they thoroughly state the factual contentions in this case. I think live testimony would simply add time to this. I don't think it's necessary at all. Now, again, my clients are here, so if you do have a specific question, I'm happy to have them put under oath and you can ask them that question. But I think both parties have submitted sufficient and ample amounts of affidavits. And again, it is a tricky evidentiary kind of thing because this is actually the first time I've done an anti-SLAPP hearing. And, you're always like, well, in a motion to dismiss complaint, it's the four corners of the complaint and whatever exhibits there are. But not for this, there's actually evidence that's got to be done because you could never, I don't think you could anticipate it when you file the complaint that you'd have to have, all this evidence with it. So I agree with Ms. Jones. I think that it's really just at this point your legal
Right.
decision.
Thank you, Mr. Carlton. And it's funny. I seem to get cases like these in batches, right? And so I'd not had one, and then fully litigated one about a month ago. And so I have had reason to recently become familiar with the relative standards and the statutory sub descriptions of what constitutes protected activity and all that fun stuff. I will say that I think that sort of legal tightrope you're talking about the interplay between 12b6 and 11.1. I think that's why that second factor under 11.1 really talks about a reasonable likelihood of success on the merits rather than, I know once you start looking at the case law about what the likelihood of success on the merits looks like, they very quickly devolve into an analysis of whether whether it can survive a 12b6. But I think that's why they try to distinguish it. Because of the fact that the 911 11.1 statute's pretty clear that you can present evidence and are entitled to some discovery and that sort of thing. And so I appreciate both of you very much trying to crystallize these issues and present them in a way that is cohesive in terms of the affidavits and some of the exhibits that have been, that the parties have presented. So I really do appreciate that. With that, Ms. Jones, I'm going to hand it over to you regarding, it is again, your motion and you can argue it in whichever order you'd like to. Like I said, given the way it was structured, I was thinking of it as a 911 11.1 motion where, you're going to tell me why Mr. and Mrs. King's actions constitute protected activity. And then if I find that it does, then we get into the merits. I understand you separately, whether I find that it constitutes protected activity or not, would like the court to consider whether the actual pleading on its own states a claim. And so it's kind of up to you which lift you want to start with first, Ms. Jones.
Thank you, Your Honor. And I appreciate and am glad the court has dealt with one of these cases recently because having all of this top of mind helps us sort that out a lot better. I was thinking of structuring it very much like the court did. Let's talk about protected activity first.
Okay.
Then when we get past protected activity, let's talk about likelihood of success on the merits. And that's where kind of the 12b6 and the success on the merits sort of mesh up. I just think, and I know the court seems to appreciate very well the different standards that are applicable slightly. So I'm going to leave that to the court to sort out as the court kind of considers everything that we've submitted at the end. But I do think those two things go hand in hand. And we'll kind of argue that accordingly. But I may from time to time talk a little bit about things that are not in the pleadings, because I think that is absolutely critical here on the probability of success on the merits. The complaint is what it is. And I think to start with on the protected activity and kind of the why we're here piece. If you look at this complaint to me just meets the classic definition of a SLAPP suit. And I think it's important to look at the case that we cited and that the plaintiffs did too, the Wilkes and McHugh case. SLAPPs are meritless lawsuits brought not to vindicate legally cognizable rights, but to deter or punish the exercise of constitutional rights of petition and free speech by tying up the target's resources and driving up costs. That's exactly what this is. We fit right into that. And when you look at the background here, reviewing the complaint, reviewing the affidavits filed by the plaintiff, the one thing that's clear, you look at those, and then also for some reason, the plaintiffs in their affidavits brought up these petitions for stalking protective orders of all things that they filed against my clients just a couple of weeks after this lawsuit was filed. You want to talk about a campaign here? There's a campaign to muzzle the Moors, or the Kings. The Moors are on a campaign to muzzle the Kings, and that's what the anti-SLAPP statute was designed to prevent, and to say, you know what, you can't come in and shut people down when what they're doing is petitioning the government. I think it's also important to kind of look at the big picture before I get into some of the details, that if you look at the evidence as a whole, and we would really ask the court to take a look at the emails, take a look at what the plaintiffs are talking about here. What the King's contentions here are, their beef, if you want to call it that, is with the city of Atlanta. The Moors are hardly mentioned. The Kings are unhappy because the city of Atlanta granted a building permit that they never should have granted, because this structure, the work that was done, the pool that was added, the paving, everything is right slap dab in the middle of the flood zone. And here it's Nancy Creek. Your Honor, I think the court lives in the city. Anybody who lives in the city is familiar with flooding of Nancy Creek and Peachtree Creek. To suggest that that's not a matter of public concern, I'm kind of struggling with. Everybody in the city knows that that happens, and knows that the city's enforcement of the floodplain regulations, the floodplain ordinances, is important not only to the neighbors, the Kings, but to everybody in the city. Is the city doing this the right way, or are they turning a blind eye, as Mr. King said in some of his emails? So that's what we're here to talk about. And I'm not going to belabor some of these standards because the court's familiar with them. But on the issue of protected activity, the court knows the standards. I would say that the particularly important thing is it is a broadly construed standard under the statute. If the court looks at the Mock decision, that's a recent case. This was Mock versus Athens Pride. It was Court of Appeals decision, and also ultimately ended up in the Supreme Court. States it very well. Any claim for relief against a person arising from any act of such person that could reasonably be construed as an act in furtherance of the person's right to petition or right of free speech.
If you know, Ms. Jones, about the argument that the Moors have made that this isn't really an issue of petitioning the government for relief because the permit's already been granted, right? That ship has already sailed. And so, I think I understand, given that the 4 available buckets, I know the 4th one is really, really broad and lots of things can fit into it, but 3 of the 4 really are at people who are speaking in a manner intended to be associated with a judicial, executive, legislative, et cetera, government function, right? They're speaking out about something as an effort to petition the government for relief. And at least part of the Moores argument, as I understood it in their briefing, was that the permit's already been granted and that's what the Kings are mad about. And so they're not really petitioning for redress.
I think that's an oversimplification, and there's a couple of responses there. One is the court still has to look at what's pled here. What are the bases of the claim? And when you look at those first 3 prongs, we agree with the court that prong 4 is the one that pretty clearly is met here. But look at the petitioning body. One of the allegations of the complaint is that the Kings filed a BZA appeal to the Board of Zoning appeal. They're entitled to do that. That fits right in the just 4 square in and I think it's category 3. And it is it's not just a court, it is any executive or administrative body. And if you look at the case law that we cited, all kinds of things, zoning decisions, noise ordinances, and it's not just whether it should be granted. That's goes to a different issue of the king's beef with the city. You shouldn't have granted this building permit to begin with. But enforcement, are they building it according to plans? Are there some other issues? That continues on, because ultimately when there's construction, there has to be a final inspection, final certificate of occupancy or certificate of completion. The city and the city building division retains authority to say, is the permit being followed? The city at any time could look at it and say, you know what? No, we shouldn't have granted that. And one of the things, and we'll get into this on the merits, that the Kings were arguing is the city's actions and what has happened here, not just specifically, but the fact that the city approved this. And if you look at even the exhibits that the Moores introduced, there's an email that refers to a process, and I'm going to try to find that one for the court, that where a state official from the Georgia EPD said, you know what, we've looked at this. Even though the permit had been issued, you've raised some concerns about whether it's actually being built in the flood zone and whether that was proper. And they said, we went back to the city, and not just the city said, as the Moores contend, oh, everything's fine. No, in that email itself, they found that there were some problems, and the state and the city made the Moores go back and say, no, some of this is not right. It's not being built according to plan. There's some problems with the plan. Go back. And then that part from the state of Georgia's perspective was concluded in August 2025. So during that whole period, March, April, May, when these emails are being sent, everything is still wide open. The state and the city are still considering what's going on here. So it's not as cut and dry as they would have the court believe that, oh, permits issued, we're all good now, it's over. That's absolutely not correct. There's this ongoing obligation. And further, because of the city's obligations to enforce and mitigate flood hazards, the federal government could come in, and if they find, hey, there's a problem with this, they could take action against the city. So that is a matter of public concern, separate and apart this building permit as to the Moores. The Kings have the right to say to the city, you know what, you're goofing up. You're not doing this the right way. You're not looking at the impact on the neighbors, the flood hazard. Is the federal government going to pull their subsidies? If you read those emails, that's what they're talking about. The Moores don't get to complain about that if the Kings are telling the city, you know what, you're putting some federal funding at risk here. Would you just have a meeting with us and help us understand what's going on? As concerned citizens, they're allowed to do that. So that is, I think it just falls squarely within that fourth subsection that the court is talking about. And the exhibit I was talking about that refers to the state is Jeffrey Moore's affidavit, paragraph 16, exhibit number 10. And we would suggest the court should take a look at that on the timing. So I think that really addresses the issues on the protected activity. And if you look at the cases that we cited in our brief, plaintiff didn't address any of those, didn't say, no, none of those cases aren't correctly decided. They don't apply here. Talk about, health inspection of a tattoo parlor, noise ordinance violations. There was one where I think there were some protesters for a development. So all kinds of things that are right four square within the issues here that get this into protected activity. So I think unless the court has other questions, I'm prepared to kind of move on to the other issues, or
I only have one other question on the issue of this petition, and I think it goes directly towards what you're about to move into, which is the nature of the causes of action. I don't want to put words in Mr. Carlton's mouth, but it does seem like part of what the Moores are arguing here is, sure, a concerned neighbor has the right to contact the state or the city and say, hey, I think they're not complying with this permit that you gave them, whatever. But it's the manner and volume in which it's been done that I think Mr. Carlton has argued sort of takes it outside the realm of this public comment and more over into the range of harassment. And how do we deal with something that potentially, I'm not saying that I'm prejudging it in that manner, but that, 1 or 2 or 10 of those types of statements might be protected, but 8,000 of them might not be, because they stray into the realm of not public comment or petition of the government, but harassment of the underlying target of those communications.
I understand your honor, and I think there's kind of a twofold response to that. First, I've looked and I have not seen a single case, and Mr. Carlton has not cited a single case where any court in Georgia has said, if you contact the government too many times, it's not a protected activity anymore. There's not a single case that says that under Georgia law. I looked briefly, if the court may recall, the statute, the current version of 911.11.1 is based on a California statute. I'm not saying I spent hours and hours looking at California law, because I didn't. I don't think that's cost effective. I didn't see any other cases from California saying, if you contact the government too many times, it's not protected activity anymore. It's either protected activity or it's not. If he wants to argue some sort of harassment, that's on the merits of the claims, but protected activity is protected activity. We're petitioning the government. The other response to that would be, look at the nature of the allegations that they're complaining about. Again, complaint's pretty bare bones. You can't tell what they're really, the details, but when you look at what they actually cite here, the volume is not about the Moores specifically. The volume is about the city. This lawsuit isn't a defamation claim brought by the city or any of the city officials. This is a defamation claim brought by the Moores. And we'll get into that later on the merits of the defamation claim, but the court needs to look at, what are they alleging specifically was said about them that was false? That's, so I think that's kind of a sidetrack of the volume. And if you look at what's the reason for the volume, read those emails. The Moore's first email, or at least the part that we have in the record now, is, hey, Ms. Connolly, would you meet with us and help us understand what's going on here? You know what the city did? They ignored it. There's not a single email where they responded. And they kept saying, hey, we're raising this issue over here. Could you respond? Could you let us know what you're going to do? So it does keep escalating. But who caused that? They're petitioning the city and asking the city to do something, and they're not getting a response. So I don't think the court can look at the quantity to say it's not protected activity. It's protected activity. It is petitioning the government. It is exercising their right to free speech. So I think that kind of addresses that part of the argument. Then we get into the probability of success. This is the second prong. The plaintiff, once the court determines this is a protected activity, the plaintiff now has to come back and show that they have a probability of success. And that's where the court can look outside the four corners of the complaint. I would say the information that they've added doesn't help them at all. It supports my position that this is protected activity, that it's really not directed to the Moores. But we do want to look there at the allegations of the complaint. On the nuisance claim, this also goes to the protected activity and the merits. They can't get over the hurdle to state a claim for nuisance. We cite ample authority that a nuisance claim, it's not a nuisance for a nuisance cause of action. It is not what we all colloquially think of a nuisance being. Something's a nuisance. Oh, my dog's being a nuisance because he's barking, or, it's annoying. That's not what a nuisance is. Georgia law is just crystal clear that a claim for nuisance has to involve some sort of an actual invasion of the plaintiff's interest in land. Being an annoying neighbor, taking pictures from your own property and taking pictures that include your property and the neighbor's property, that is not a nuisance. Georgia courts require that it be something to be a nuisance. It's something that invades your interest in land. There's all kinds of cases: water, obnoxious smoke, loud noises, bright lights, those kind of things that actually invade your property and affect the property. Those kind of things can give rise to a claim for nuisance. We looked. There's not a case that I could find showing that. Again, what did they allege? Surveillance. And then we're back to this same thing, not just surveillance. What they're really talking about is, and you sent a whole bunch of emails to the city. Surveillance and sending a whole bunch of emails to the city. That has never been recognized by any Georgia court as supporting a claim for nuisance. Mr. Carlton didn't cite a case. If there had been one, surely he would have cited it. There's not a single case that says Georgia law extends a nuisance to these types of activities. And I just think that's pretty clear under Georgia law that this is not the type of thing. The allegations are not the type of allegations that could support a claim for nuisance under Georgia law. So that claim must be dismissed under the 9/11-12b6 standard, and there is absolutely no way. There are no facts the plaintiffs can come up with within what they've pled and what they've shown to the court that support a claim for nuisance. And we will, Your Honor, I would like to reserve some of our time to talk about whatever Mr. Carlton comes up with. So I'm not going to go into kind of
Well, it's
chapter
your
and
motion,
verse.
so I'm always going to let you have the last word. And so, you feel free to present what you think is necessary, and then you absolutely are going to get an opportunity to respond.
Yeah, understand. I just don't want to kind of waste the court's time on things that maybe aren't a big issue. But I think the whole issue of the harassment, honestly, the court can read these affidavits, but for the plaintiffs to have brought up this petition for a temporary protective order, a stalking protective order, that was frivolous, false, completely unfounded. We showed up in court to contest that. They were accusing them of being predators and taking photographs through the windows of the home, which just couldn't be farther from the truth. And we did reach an agreement that those claims were dismissed. Plaintiffs didn't mention that in their affidavits, but the court entered an order saying, you agreed, they were voluntarily withdrawn, and you can't come back with those same allegations. We think it was unfounded. It's impermissible. I hate to even have to talk about it, but even if you assume all of that is true, standing on your own property and taking a photo is not a nuisance claim. If you can prove that it was something else, and oddly, the plaintiff alleges in their complaint that they sent a notice to the Kings saying, hey, we're going to call the police. Mr. Moore sent an email. We're going to call the police on you because of this Peeping Tom statute. Mm-hmm. Well, the Peeping Tom statute involves actions on the plaintiff's property, on the victim's property. They don't even allege that the Kings ever came over there and did anything. And I think, Your Honor, that kind of goes to show what the intent of this claim was. The overall, when you look at the big picture, the intent is to shut these people up and to make them stop complaining. It's not about them taking pictures of the drain pipes or the building that they think maybe is put in the wrong place, the outbuilding. It's not about that. It's about them communicating to the city, and the Moores don't like it. Skipping from the nuisance claim, now we get to the probability of success on defamation. And it's our position that the complaint, looking at its four corners, does not state a cognizable claim for relief, and that the supplemental materials submitted by the plaintiffs on the 9/11 11.1 claim don't help in that regard to show a probability of success. And we'll take those through. I know the court's familiar with the standard for defamation. The first point I would make here is looking at the four corners of the complaint. The court may also consider that when the court is thinking about what was the purpose. Is this a SLAPP suit? If you look at the four corners of the complaint, the vast majority of the allegations occurred too late. They're time barred. Most of them were before, the court knows, 1 year statute of limitation on claims for defamation. Only publications that are within 1 year of the filing of the lawsuit, that's 9/3/33, are cognizable. There's a case on that we didn't cite. It's McGee versus Gast, 257 Georgia App. I think I may have the wrong site here. Also the North Atlanta Golf case that we cited, but it's really clear. You got a year. You look at the complaint, paragraph 6, 2022. Paragraph 9 of the complaint, contacts with the city in 2024. That's out. Paragraph 10, questions about the project, unspecified date. But if you read the complaint, it looks like way before in 2023 or 2024. Paragraph 11, spring 24, the BZA appeal. Paragraph 13, emails to the city right after this letter of March 2024. All of those, none of those claims are viable. The only
What
thing,
about, but what though, Ms. Jones, when you get into this range of a 12B6 motion? I mean, given the state's very liberal amendment policies, right? I mean, the Georgia law provides that you can amend your complaint at any time prior to the entry of a pretrial conference or the pretrial order. And we are, 2 months into this lawsuit, barely 3 months into this lawsuit. Presumably, the lack of specificity and the jettisoning of claims that would not survive a summary judgment motion on statute of limitations is something that the Moores could fix by amendment. Why does that not address the problem here?
well, they do have some allegations about 2025. My point here is, if you want to wonder whether, is this a frivolous lawsuit that sounds a lot like a SLAPP suit? The fact that you include, most of your allegations are talking about things that just clearly and unequivocally are time barred. That tells me what the point of this whole thing was. Do they have something they can salvage? Yes. What we're really talking about here, the only potentially viable claims are the ones that occurred, are statements that were made after March 2025. So my point to the court would be, when you're parsing through, and even when the court is considering the liberal amendment possibility, when you're looking at the affidavit, when you're looking at the emails, anything that happened before February 26, 2025, as far as defamation goes, we're not going to be talking about that. There's going to be a motion for summary judgment on that, and that's what the court can consider. Under 911.11.1, that second prong, the court can say, no way, no how, any of these actions, any of these statements that allegedly occurred in 2024 or before February 6th, no way, no how they will ever support a viable claim for defamation. That's really our point there. There's a whole lot of stuff that's getting thrown around here that the court doesn't need to pay any attention to. So we really need to look at what is alleged, and then what evidence have they come forward as far as the probability of success for these comments and statements that were made in 2025. Then we have to look at what are the elements of a libel claim. False and malicious defamatory statement about the plaintiff. Statements about somebody else don't count. Statements about Rose Donnelly, I think her name is, at the city of Atlanta, don't count. Statements about the plaintiff are the only thing that the plaintiff claim are defamatory.
Isn't there, and admittedly, I only saw this in passing, but isn't there an allegation that Mr. King floated around some sort of indictment alleging that the Moores had engaged in criminal behavior? I mean, depending on the timing of that type of allegation, that would seem to fall pretty squarely into the bucket of an allegation against these individuals.
That's what Mr. Moore's affidavit would have the court believe. I would ask the court to read those emails very carefully, because that is not what they say. I don't, I don't want to use the term gaslighting, but I almost do want to use the term gaslighting. That is not, maybe he's just being an advocate for himself, but the court does not and may not consider his conclusions about what a statement is. The court needs to look at the statements themselves. And it's very clear that, and again, remember on defamation, rhetoric, hyperbole, that's not a statement of fact. The Kings are not and did not accuse the Moores of being co-conspirators. What they said when the court reads those emails, after having been ignored by the city for a while, when they said, hey, meet with us, help us understand why this permit was issued, because we don't think it should have been. We think that things that are actually being constructed are not okay. Meet with us, help us understand what's going on. They said, to kind of make that point, that Mr. King, I will say it looks, he did get pretty deep into the rhetoric and the hyperbole, but threw out an example. If the federal government came and asked us what we've seen, what we think, this is a hypothetical thing that could happen to you, City of Atlanta, if you don't pay more attention to this stuff. They never said that an indictment had issued, would issue, never accused the Moores of actually being co-conspirators. They were saying, you, the city, are violating some pretty important duties that you have. And if the federal government comes poking around here, we think that's going to be a problem for you. Will you sit down and talk to us about it? They use some rhetorical flourishes. No question about that. The affidavit and the brief, comment about, referring to Ms. Donnelly as Your Majesty. Your Honor, we don't, we may not all love the way the No Kings protest.
I wasn't that all worried, because I agree with you that is rhetorical flourish, I think is the right way to put that. I wasn't worried about that, but
rhetorical flourish, again, like most of the rest of this, about somebody else. If you look at all of this, it's about the city and saying this thing that you did, as exemplified by what's happening next door to us, is a problem. The way you're viewing these things is a problem. The exceptions you're allowing, where some people get to build a swimming pool and pour lots of concrete and all of this stuff literally in the flood zone. And we didn't get to do that when we wanted to bring some dirt in to fix some erosion. That's, if you look at, and you've just got to drill down into what these emails actually say and what are they about, and not just rely on the generalities and the conclusions that are in this affidavit and Mr. Moore's spin on it. But we would just ask the court, take a look at the emails themselves, and look at what is alleged to be a false statement of fact, not opinion, not rhetoric, about the plaintiff. There's plenty of case law that we cited there. They kind of gloss over a lot of the actual content of these affidavits. They want to talk about libel per se, an accusation of a commission of a crime. But if the court looks at that, that's not what's alleged at all. You have to, again, actually look at what we're talking about here. The libel per se is 51.5.4. The words at issue must charge the commission of a specific crime. That's not what happened here. Using a term illegal activity, that's not libel per se. And here we're kind of, that kind of wanders into, and there was a little bit of blurring in their brief about the issue of the privileged communication, but there really aren't specific statements of fact charging anyone with a particular crime punishable by law. Again, if you're going to talk about libel per se, a crime punishable by law, violation of a city ordinance, again, without specifying it, doesn't cut it.
And Ms. Jones, forgive me for interrupting you, but I've been letting you go for about a half hour and I was going to transition over to Mr. Carlton. But before I do that, I wanted to give you an opportunity to sort of any last words or last, argument on the topics that you want to be heard from before I hear from Mr. Carlton, understanding again that you will get an opportunity to rebut.
You bet. And that's really the point of, I think for the court, the big point here, there's only a handful, a very small handful of specific factual statements about the Moores that are alleged to have been made. 2 of those were from 2024. You can look at the affidavit, you can look at the exhibits and figure those out. Those don't count. So we won't address the details. They are addressed in the King's affidavits. Then when the court looks at the drift of everything else, kind of that March through May timeframe, the complaints about the city, those statements are virtually all about actions of the city. And the Moores are mentioned incidentally as the people who built the house in this illegally issued building permit. So we would ask the court to look at and parse that out, because that's what they've got to do. And they're just not able to point to anything that's a false statement of fact when you really look at the evidence they submitted. And I think that's probably a fair thing to stop with. I would say the standard, I expect they're going to talk about the qualified privilege issue, but we would say most importantly, you don't even get to the element of unprivileged statements if you can't find false statements of fact about the plaintiff. The whole thing ends there. We don't even start talking about qualified privilege, and I can talk about that issue in response to Mr. Carlton's argument.
Okay, thank you, Ms. Jones. Mr. Carlton?
Thank you. I want to address 3 things first. One, I'm not going to be coming up with anything as far as her response. I don't appreciate suggesting I'm going to make something up here. The briefs are briefed. I don't think there's I didn't put in any false statement of facts, and I haven't blurred anything. Now I'm going to address a few of the points made, and then I'll get into my argument. The first is there are allegations of violating specific environmental laws. They state clearly that they violate city code, state environmental laws, and federal environmental laws. And then, so that is as to the libel per se.
But is it defamatory to not comply with an environmental law?
Yeah, you can be fined or put in jail if you.
No, I understand bad things can flow from not complying with it. But if I were to say that Rachel Krause, she uses fertilizer that's illegal in her backyard, is that, that would be a violation of environmental law. Is that defamatory?
If it's false.
Okay.
So we have a defamatory. They're accusing my clients of violating the law, the environmental federal law. The emails are, I've submitted some to you, accused of violating the EPA, accused of violating Georgia EPA, accused of violating city code. Those are crimes. If you go out and dump a bunch of tires illegally and set them on fire, you're going to be charged. That's a charge. And then as to the wire fraud, that's a criminal charge. And this is really important. The claim regarding the Acela portal. So the city has an Acela portal where contractors post their permits, get their permits, they request, all right, we've finished the electrical. We need someone from the city to come out and check the electrical and say we passed so we can get our certificate of occupancy. Well, what Mr. King did was he went into there and actually tried to schedule the arborist to come out to do the inspection on the property. The arborist isn't going to know that it's not my client or my client's contractor. So then my client sees on the Acela that they're coming out for an arborist inspection, which wasn't requested by his contractor or my client. And so he contacted the city, and the city cancel it. They didn't come out to do the inspection. So Mr. King's response to that was that my client committed wire fraud in having the arborist not come out to do the inspection that he requested. And none of that is privileged. Going on to a portal and acting like you're allowed to be requesting these things is not privileged. The issue of my notes are around it's like a bunch of circles. So just give me a second. I want to make sure
I
I
understand,
get
don't worry.
everything. So that's with the Acela. Now I want to talk about the nuisance versus libel, because the Kings are trying to argue that any of their behavior that's more than a year old can't be subject to liability. I agree that it can't be subject to liability as to the defamation, the libel, but that doesn't say that all the 8,000 emails that happened more than a year ago aren't part of the nuisance claim. And yes, I readily agree that this is a pretty unique argument for nuisance claim.
And thank you for getting to that, because that was really the conversation I wanted to have with you. Ms. Jones has, argued that the nuisance claim is a very specific thing. It is definitely tied, as it is structured under Georgia law, to an intrusion on land. I think I understand the argument you're making, that given how uniquely tied to the land this issue related to permitting and whether the property can exist in the way that it has been permitted and intended to be built is a unique tie to the land itself, or to the real property structure there. But help me understand that.
Well, all right. So I'm just going to read the statute. I think that's a good way for me to start, if you don't mind.
Go ahead.
Okay. A nuisance is anything that causes hurt, inconvenience, or damage to another, and the fact that the act done is otherwise lawful shall not keep it from being a nuisance. So their argument is they can send 8,000 emails, which causes my clients damages. We allege $75,000 of damages because of all these. Constantly they're like, hey, you got to check this. Hey, you got to check this. Hey, every time they do that, someone from the city comes out and has to inspect and look. And it's not just a matter of the time that this has slowed everything down, which it has slowed everything down. It's the money. They've had to hire engineers to come out there and show to the city, no, this is allowed, what they're doing. They're in compliance. So that is a nuisance. It's an inconvenience to their property. And again, also, peering up into my client's children's bedroom is part of the nuisance claim as well. It is. We have pictures. Whether they could see into the window or not, I can't write an affidavit to say that Mrs. King knew that the kids are up there in the bedroom and that she's staring at them. All I can say is that we have pictures of her looking up at them through that window on the property line. And that we've attached several of these. There's all these photos of them like snooping through the trees. One of them, they're pretending like they're picking up sticks, but they're putting my clients under surveillance. So again, that's all part of the nuisance claim. I agree it's unique. I agree. But it seemed like it fit the pattern to me. So when I read a statute, unless someone tells me, if Georgia Supreme Court says this isn't a nuisance claim, okay, then it's not a nuisance claim. But if I've got a statute that's written the way it's written and hasn't been told it's not, then I don't think it's a blurring of facts to bring this claim.
Back up a little bit, Mr. Carlton,
Yes.
and talk about that sort of first step, right? Because the court doesn't have to get into determining whether the merits of the claim demonstrate likelihood of success on the merits if the court determines that Mr. and Ms. King's actions don't constitute protected activity under 9/11/11.1. Specifically the subparagraphs that define what protected activity is.
Let me get to that. Let me get to that, Your Honor. That was what I was initially gonna start with, but I just want to kind of hit a few of the points that were made, so that I wouldn't forget about that. So let me get to that here now. Go one sec here. All right. Yeah, as 9/11 got four different provisions that it could be qualified privilege. And again, it's really important to stress it's a qualified privilege. This isn't an absolute privilege. We know what an absolute privilege is. If you file a lawsuit and accuse somebody of doing something, that's absolutely privileged. This is an argument of qualified privilege. The first one is any written or oral statement or writing or petition made before a legislative, executive, or judicial proceeding. There is no judicial proceeding going on at this point. The only one that wouldn't be a judicial proceeding would be the statement about appealing a zoning, an appeal of a zoning. Yes, it's clear that if you have standing to bring an appeal to a zoning decision, that I agree that specific statement would be qualified privilege. As to the second one, any written or oral statement or petition made in connection with an issue under consideration or review by a legislative, executive, or judicial body. Again, that doesn't fly here for every single statement made after the permits are made and after their zoning appeal is denied, because there is no current proceeding. Now, again, if say my clients decided, all right, we're going to do this now, we're going to build a 300-foot tower of the goddess Athena in our backyard because we're totally into Greek mythology, they could then say, hey, city, why they can't, they're putting up a 200-foot statue in their backyard. Clearly, that would be qualified privilege. And it would be a petition about them doing that act. But let's say in some way the city council, the state, and the federal government decides that 200-foot Athena statutes is what we are really into, and it's allowed, then you could argue that that's a ridiculous argument. Let me move on. All right. Sorry. Sometimes I get carried away. The next one is a written or oral statement, a writing or petition in a place open to public or public forum. Emails to all these officials, plus keep in mind, at least 3 of the people getting these emails were not city officials. They
Well,
were private
forgive me,
individuals.
right. Forgive me for interrupting you on that point, right? I mean, certainly statements, I think these are probably loosely statements about an issue of public interest in theory. But as I understand paragraph 3, it really has to be truly in a public forum. And I don't know, even group emails to a big block of people, I'm not sure that qualifies as a public forum in the same way that posting it on social media or that stating it in a public forum like a hearing or something like that. So I don't know. I mean, as I mentioned while I was talking to Ms. Jones, that fourth one tends to be the largest bucket that we spend the most time dealing with because it is so broad and it's sort of intended to reach out and grab any type of conduct that would be in furtherance of exercising one's right to petition or redress grievances with the government. And I think most loosely, the universe of these emails could be characterized as that. What say you on that issue, Mr.
Well, I mean, I literally in my brief, I said the only one that arguably they have an argument is bucket 4.
Yeah,
So
sure.
had bucket 4 been one, I would have gone to that one first. I'm just doing it chronologically. So, all right. So thank you. I will focus on bucket 4. Just give me 1 second if you
Not a
if you let
problem.
me. All right. So basically, the argument that I made in the brief, and I make it again here, is that while that may have been in play for a period of time, the city has ruled. The city has granted the permits. I mean, the city, after getting these complaints, after granting the permits, even refers to them as disgruntled neighbors. So it can't forever be something that is of public interest that they're trying to change because the city's ruled on it. And again, that goes back to this isn't harmless. This has caused thousands and thousands of dollars of damages due to their attempting to keep my client from doing this renovation.
Right, but I mean, I think Ms. Jones would argue, and I think she did, that the issue really is with the city of Atlanta here, because if Mr. King sent all these emails and the city of Atlanta fully ignored him, as apparently they allegedly did in the beginning of this process, then he could have still sent those emails and they still could have been harassing, but the Moores wouldn't have actually suffered any damage because the city didn't say, hey, what's the deal with this? And then the Moores felt obligated to go and undertake the hiring of an expert or to undertake some remediation action to demonstrate to the city that the complaint was invalid. And that really is an issue of the city. That's the Moores reacting to the city's inquiry. And I understand your argument is the city's inquiry only exists because of the King's,
Right. But also, again, they circulated a grand jury indictment. I guess it'll be up to you to determine whether they were trying to draft a grand jury indictment or not. That's in my brief. As you know, I think this is what's critical. All right. Well, I guess this is going to I guess that's going to the underlying claim about whether it's in good faith connection with. All right, I'll get to that in a moment. I do want to make a point about that because we certainly. You mind if I do that point right now and then go back to what you're asking about?
That's
Thank
fine.
you. All right, so the issue, as you know, the qualified privilege quote is not a qualified privilege if it is used merely as a cloak preventing private malice and not bona fide in promotion of the object for which the privilege is granted. That's the Oaksul versus Matthews case, which basically rejected the New York Times analysis for malice. And then so you go to the four he acted in good faith in connection with interests to be upheld. The statement was properly limited in scope and occasion, and publication was made to proper persons. So I think both C and D are a problem for the defendants. The statements aren't properly limited in scope and occasion. If you send the same blast email 30 times, that is not limited in scope and occasion. That is 8,000 emails. The second is publication made to the proper persons. So even assuming that they were simply requesting them to redo their decision, trying to convince them that they're wrong about granting permits, the fact that non-city of Atlanta people or federal government people or the district attorney were getting these emails shows that publication was not made to proper persons, and as such, they can't rely on the conditional privilege because it was not in good faith, because they made the pool of people getting these communications very wide.
Isn't
All right, so let me go back
that
to
issue one about, I mean, I guess here's my point. My question is, isn't that really an issue? If I get to the merits of the claim, I mean, the standard of whether a complaint survives a 12B6 dismissal is pretty low. Aren't those factual issues that the court should refrain from engaging in if I'm looking at the relative merits of the complaint? In terms of, if you have stated a fact on which evidence could be, presented on those issues, right? I mean, I guess my question is, procedurally, the way I'm thinking of this is if we weren't here on an anti-SLAPP motion, right? If we were here on a 12B6 and we were talking about privilege, wouldn't I be telling you guys that's a summary judgment issue after you've developed facts about whether these statements are conditional or whether
Correct. I agree
privileged or
100%.
otherwise?
I
Sir?
agree.
Okay.
So I agree with
Okay.
that for sure. So I guess you just want me, you want me to focus on the bucket of 4 items. And
Well, I do think that I think the 2 things that would be helpful to me for you to focus on, Mr. Carlton, is one, that sort of the bucket of how this qualifies as, I assume from your perspective that it is not protected activity. Number 1, and that's bucket 4, or any other bucket that you think it doesn't qualify under. But the other issue is I think I understand the defamation claim, including some of its defects that are pointed out by Ms. Jones. But I'm not sure I understand how I'm not sure I understand how the nuisance claim qualifies here. In terms of it being, I mean, I understand the language, the statutory language that you're referring to, but it historically it is something that's got to be tied directly to a nuisance to the property. And so I'm still trying to understand that. So those are the 2 issues that the court's
Sure.
going to be focused on. And so I want to give you an opportunity to
Yeah,
tell me your position on those.
yeah, so I mean, the nuisance claim is about the property. That's why we brought it as a nuisance claim. They're trying to keep my clients from renovating the home they purchased, and that home is on real property. And also in our, we raised in our brief that they challenged the pins from the survey from years ago. This all has to do with the property. Every single thing. If my clients were not their next door neighbors, we wouldn't be here because they wouldn't have an issue with my clients wanting to put a swimming pool in their backyard. This is trying to stop my clients from legally developing their property. I mean, it's plain and simple. It would be no different. Their goal, I mean, part of they've requested that the city have the whole renovation torn down. That would affect the property if all of a sudden they have to tear down their renovation. That's clearly connected to the property. It's a developed real property with the home on it that's in the real estate deeds, and they pay taxes. They pay property taxes. They have to pay for permits to develop it. So that's all part of the property. Again, I agree. There's no case law on that. And so, but I think it certainly is an item of first impression. Certainly, it suggests that there's claims. Plus, again, it's the going on to the Acela. That is to try to get them to be found in violation of tree ordinances on their property. Every single thing relates back to my clients buying this house and wanting to renovate it and putting a pool in. So that all connects to the property. No, I don't have a case from New Zealand or New Hampshire telling it otherwise. My daughter's actually just about to graduate from Georgia Law School, and we always we're nerdy, so we like to talk about old common law cases, and there's some good cases from New Zealand. So that was why I said that. That doesn't matter. We actually talked 2 days ago. We were talking about New Zealand in a case. So it is all tied to the land, and I think it clearly fits the statute as it's written, whether someone has come up with this theory before or not. It most fit the standard to me. And as to the bucket, we keep calling it a bucket. I'm not sure if anyone calls it a bucket in their cases.
I don't think they do either. I'm just, there's 4
pot.
and it's got to
A
fit into
pot.
one of the buckets.
It's
is
a
how I
bucket,
think of
it's
it.
a pot, it's a pocket. We know what we're talking about.
Yes, sir.
So there again, it clearly says in connection with a public issue or an issue of public concern. The Kings want to say it is a public issue and public concern, but it's really not. It's a concern to them because they're their next door neighbors. It may be a concern to, and let me actually address something that I think is in my brief. The Kings in all their missives to the city and the state and the EPA always talk about them and other people are concerned about what the Moors are doing, but they never identify who these other people are. So it's creating a straw public issue by saying others are concerned, but they've not provided any evidence that anyone other than themselves is concerned about this. And so it's not a public issue or of a public concern. And then once the city has determined that they're granted their permits and can do the work, it's no longer a public issue or public concern. And I think I mentioned this in my brief, and I think it's in the affidavits. There's again, it's not an overly broad standard, and for like one example, to show how this isn't really a public issue, a public concern, and in fact is just a private obsession, which is what this is the emails about that the Kings alleged that the Moors dumped when they did the renovation, they dumped all this asbestos in their backyard. And the Kings explain that 30 years ago, the prior owner of the house had said that there was asbestos in the construction. And so the renovation happens. Obviously, if there's asbestos everywhere, they're not going to get these permits. The city's going to come out. But what makes it even more fanciful is the Kings literally put in an email that the Moors had all this asbestos. They dug a pit in their backyard and buried the asbestos. And when they contacted the city about the asbestos, in the middle of the night, the Moors had contractors come out, open up the hole they dug in their backyard, put all the asbestos in a truck, and hauled it off so that they wouldn't be charged with having illegally dumped asbestos. That's an obsession. That is not a public issue, public concern. Yes, asbestos is a public concern, but you can't just make it up and say, hey, you got to get the asbestos out. And then when there's no evidence of asbestos, their argument is, well, they had it in the middle of the night. The contractors came in, which would be a violation of the Atlanta Municipal Code. You can't do work until after 8 a.m. in the morning. So I don't know why they didn't call the police on that. But anyways, that is why that fourth bucket, whatever you want to call it, doesn't apply in this case. And so that is why we believe that they don't get to the first requirement to satisfy themselves to have this case dismissed on the SLAPP statute.
Thank you, Mr. Carlton. Anything else before I let Ms. Jones have the last word?
No, I think you've read the briefs and understand the facts, so I'm not going to belabor it. And I think you've told me your issues of what you wanted me to respond to, and I've done that. So, I say this to every judge that does this before case. I was a law clerk for 2 years, and I really do appreciate judges that actually look at the filings before the hearing. So I do appreciate that, and that's all I have.
Thank you, Mr. Carlton. I appreciate that. Ms. Jones, your response? You're muted, Ms. Jones. And I always say it wouldn't be a Zoom hearing if I didn't have to say that at least one time.
That is correct. I turned myself off there, and I appreciate the court notifying me quickly. And I will try to just touch on a couple of the points that Mr. Carlton made and a couple of the questions the court asked him. First, on the and I'll hit the nuisance first, even though we talked about that. I want to kind of pull back to a couple of things he said. One, regardless of the 9/11/11.1 motion to strike on the nuisance, regardless of whether it's a protective activity, remember, we do have pending a 9/11/12b6 motion on the nuisance claim. Regardless of protected activity, the court has to look at, does this state a claim for nuisance? Mr. Carlton said something really interesting. A court's never, I'm looking at the statute. The statute itself says, a harm. A court's never, it's a first impression. Well, a court has talked about that. An appellate court has said, this way that you're wanting to read the statute, no, that's the Blondell court. The plaintiff in that case argued anything that causes harm is a nuisance. The Blondell court said, nope, the hurt or damage must arise from acts which affect the land itself. Taking pictures of the house, surveillance, all of that does not affect the land itself. That just the court's instincts are right on that. And I will say what's good for the goose. If surveillance is a nuisance, guess what? The Moores have admitted many, many, many times that they have cameras trained on the King's property. We will be talking, if that's a nuisance, we will be talking about nuisance a lot in this case, and there will be a counterclaim. I don't think it's a nuisance, but they say on the one hand, it's a nuisance when they take some pictures and videos of us, but it's not a nuisance when we have cameras pointed at you, and when they claim we're taking thousands of videos and photos of you. Really, it's not a nuisance. That's what the law is, and we would ask the court to grant the 12b6 motion on that issue. Then to get to, the court made what I think is a really important point on, and I won't parse through every single statement, the statement that's alleged to form the basis of an action for defamation must be defamatory. It must be something, and I'll read here from the statute, and there's a case that we cited, the ACLU versus I'm not sure how to pronounce that one, but the statute itself, a statement tending to injure the reputation of another, exposing him to public hatred, contempt, or ridicule. In the city of Atlanta, a claim that, hey, you're not following the building permit just right. You know what? That's not subjecting you to ridicule. You've got to look at these statements and say, do they meet that criteria also? So I think that's the court made a very important point there. Violation of a city ordinance probably doesn't qualify. You've got to look at the nature of what's being alleged and whether it qualifies. And we'll let the court, look at those. This whole thing about the Excella portal. Again, I would ask the court to review that particular email and review the King's affidavit about that. There is no, again, is there a defamatory statement in there? And I'll just go through that quickly. I'll tell you which exhibit that is. It is exhibit number 11. If you just read the emails themselves, they don't support this idea that Mr. King went into the portal and set an inspection. I can't go into the Excella portal and ask the arborist to do an inspection of a tree on your property, Judge. I can't do it. I tried, not the court's property, but I poked around to say, is this right? Is this possible? It is not. What the city's website does say, as far as the tree ordinance goes, anybody can complain about a problem with a tree, or that a tree has been treated incorrectly based on a permit or whatever it is. You do that by contacting the city arborist and asking them to do an inspection. That's what the Kings did here. Look at their affidavit and look at these emails that the plaintiff submitted, not their interpretation of it, not their speculation about who did what. Look at the emails.
And you were saying that's exhibit 11 to Mr. Moore's affidavit?
That is exhibit 11. The
Okay.
city arborist, when Mr. King said, hey, we contacted you and asked you for an inspection. It looks like that's been canceled in here. What's up? And the city arborist said, I don't know. I checked with my people. They said an anonymous person canceled the appointment. Now, Mr. Moore in his affidavit admits that the anonymous person was him. Well, you know who set that inspection? The city arborist at the request of the Kings. So they've got it all backwards. But in any event, there's nothing in that email that is a false statement of fact. Mr. King does not accuse Mr. Moore of doing anything illegal. He says, if that anonymous person hacked into the system, hey, city, that's a problem. So I don't want to beat that dead horse, but the court has to really parse what the brief is saying and what the allegations are saying and whether that's what the email actually says. Same thing about the asbestos. The only factual statements in that sequence of emails is that Mr. King said, hey, you know, years ago, the people who built this house told me that there's asbestos insulation in here. I saw them burying a bunch of stuff in the backyard. I saw them dig it up. I didn't read that email to say in the middle of the night, but whatever, it doesn't matter. They don't contend that it's false that he was told that there was asbestos in the house. They don't contend that it's false that he saw materials being buried. He can't tell what it is. He's on his property. And he said, hey, could you go out there and test? You know what the Giraldi case says? If you have a good faith basis for asking a government entity to go do an inspection and go test, you're allowed to do that. It is not defamation, and it does not survive a 9/11 11.1 motion. And in the Giraldi case, the appellate court reversed the trial court because they said, well, it was found that there wasn't anything, there weren't any health violations. That's not the point. Whether they found asbestos or not, that's not the point. The point is you're allowed to say, I saw something, and based on what I know, that might be a problem. Could you go test? And they went and tested. You're allowed to do that under Georgia law. Going quickly to the main point that the court I know is concerned about, this whole public interest. We agree that the fourth bucket prong, whatever you want to call it, seems to be the one here, a public interest. I want to make sure we make clear what at least part of the public interest here is, regardless of when a building permit is issued, regardless of what the city does with the permit. The issue here is, I'm going to quickly go through this statutory, the interaction between the federal and the city. The federal government has the authority to enforce flood zones. There are things the federal government does around that. They have what we all call FEMA flood insurance. They subsidize that for citizens. The federal government contributes funds toward that. And what they do, though, and they give money, they give certain subsidies to both the individuals and to the city. And what they do is they require the city to enforce the flood mitigation ordinances and the flood mitigation laws. What the Kings were saying is, City of Atlanta, and if you read it, there is an email that is in this batch where they go through at some length about explaining to the city what that concern is. And I will point out for the court where you can find that. That is in, and unfortunately these pages aren't numbered, Exhibit 1 and Exhibit 5. There is an email dated May 5th, and they go through some bullet points where they talk about, well, actually March 25th, they go through some bullet points about the National Flood Insurance Program, annual insurance premium subsidy, and if the city is not doing what it is supposed to be doing to enforce the flood zones and to do things that prevent flooding, and by allowing all this stuff, allowing the compaction, the material to pile up, the pool, all of that, if they do that, the city has a pattern of doing this. They're saying this is an example. If the feds find out about this, and for whatever reason the feds decide, Homeland Security, FEMA, we're going to look at Atlanta. You've had a flood. We're going to see if the city's doing what you're supposed to do. You might have a problem if you don't do better than this. That is a matter of public interest. If the federal government comes in and says City Atlanta is not doing what it's supposed to do around enforcing the flood mitigation laws, they can pull the subsidies. The federal government can come in and order that buildings be demolished. They can order that buildings not be occupied. The federal government can do a whole lot of things. So it is a matter of public interest. It's not just about the Moores and their permit. There are some complaints about that. There are some concerns about that, but it's not just about them. Read the exhibits, and that becomes loud and clear. Probably the other thing I would urge the court to look at on the, I think it's Oksui. I tried to find a YouTube to tell me how to say that, and I'm still not good at it. But in that case, the court did look at the issue of, is it the New York Times actual malice standard, which is a very, very high bar, or is it the standard of ill will?
Well, but again, Ms. Jones, let me just say, I mean, the point I made with Mr. Carlton is, if I'm getting down to the weeds of whether there's a privilege that attaches conditionally or otherwise, isn't that a factual issue that goes well beyond the four corners of the complaint and whether or not there's a sufficient cause of action stated that could be developed through discovery?
In that case, the court may, but there is, on the issue of what, when the court's looking at this second prong of the probability of success, while the court must assume certain facts to be true, the purpose of that is, and there's case law that says it, the Wilkes case talks about it, the court still must consider that in the context of the applicable standards. And what we're saying here is, if they're going to claim that this is a libel per se, if they're going to make a punitive damages claim, it is not the ill will standard. It is the New York Times actual malice standard. They have not pled or offered any evidence, which they were obligated to do in this hearing, to show that they can meet that standard. And the court can look at that and say, I don't see how here there's anything that amounts to the actual malice standpoint. And if they want to bring a punitive damage, there's a quote near the end of the Oksui case that says that. It says actual malice, this is the finding of the Oksui case, is not the standard that applies when a plaintiff seeks to overcome a conditional privilege defense under Georgia law, unless the plaintiff is a public official or public figure, not the case here, or unless he is a private figure seeking presumed damages. Presumed damages refers to libel per se, or punitive damages related to a matter of public concern. So if the court finds public concern, then qualified privilege does become relevant, because then the New York Times actual malice standard would apply. And we're arguing to the court, if they're going to make a claim for punitive damages, and this is a matter of public concern, so it's two prongs, punitive damages or presumed damages, matter of public concern, we are right in the thick of the actual malice standard. And there is nothing here, no allegations, no evidence submitted here today that would show that the actual malice standard, from the New York Times could ever be met in this case. So that's I guess the thing I would close on. If that is how that's relevant, Your Honor, I think that's, I don't think we have to get there. I think if you parse the other arguments that we make that are a little more straightforward, is there a statement of fact about the plaintiffs that was false and defamatory? I don't think you're going to get to the conditional privilege issue anyway. But I think those are the key points that I would make in rebuttal to Mr. Carlton's argument.
Okay, thank you, Mr. Jones, Ms. Jones and Mr. Carlton. So I want to thank you both again for your efficient presentation of what are fairly complex issues. here's what I think I've made clear from my questions. My intention is to spend a little bit more time with the supporting documentation before I give you a ruling. But I mean, I think it's pretty clear from my questions. What I'm focused on is this, do these qualify? Do the defendants' actions qualify as protected activity? And I obviously will be mostly focused on that bucket 4, which is, I think, is the broadest one. And assuming that they do, right, as we've spent most of this time discussing, that's not the end of the inquiry, right? Even if the King's statements and actions qualify as protected activity, if they also potentially constitute tortious action, right, then they're still actionable if the plaintiff has demonstrated a likelihood of success on the merits. And based on my questions, I think y'all can clearly foresee that where I'm going to be focusing, I'm not sure about the nuisance as it's framed here, right? And where I'm going to be focusing most of my effort is on this issue of the defamation claim. But primarily, I don't know that it matters that much how you dress it up as a nuisance claim or otherwise. That ultimately, I've also got to balance that with the idea that on a traditional 12b6, even if the court were inclined to dismiss one or both or all of the causes of action because of the pretty broad amendment standard, that is going to play into the court's assessment as well. That's just sort of previewing what my thought process is about what I'm going to be focused on. Number one. Number two, logistically, what I often do is sometimes I draft my own orders like from scratch. Sometimes what I will do is email the parties and say, this is how I'm going to rule. One of you please provide me with an order, whichever one of you is the prevailing party in that scenario. And so that would be the likely what you could expect. I understand under the circumstances that the parties have asked, this is being handled on a pretty expedited basis. And so I understand that. And it is my intention to keep that in mind and try to provide you with an expedited ruling. But that doesn't mean it's going to be in the next few days. So just to be clear in terms of what you can reasonably expect. Any questions for me in terms of how I'm going to handle the matter logistically or anything related to that, not substance? Ms. Jones?
Not for plaintiffs.
Okay, Mr. Carlton, Ms. Jones?
No, not from us. The only thing we would point out is because we filed the 12b6 motion and the 9/11 11.1, discovery is stayed.
Right. So
we understand the court may need some time to take a look at everything, and we understand all of that and are available if the court has any issues that you'd like us to address further in writing.
Okay, excellent. Thank you both. I hope you have a
you.
nice weekend,
Thank you,
and
Your
I
Honor.
will be in touch. Okay, Mr. Melhorn, Ms. Smart. I apologize.
Yes, Your Honor.
It took longer than I had expected. So as I said, we are here because Ms. Smart filed a motion for summary judgment seeking to dismiss or seeking to summarily adjudicate the cause of action that was asserted by the plaintiff. Ms. Smart, I have read your brief and seen the argument you have made regarding this argument that Bank of America doesn't have standing to sue you on that credit card. I think I understand it to be the argument being that in some manner Bank of America has sold that debt, I think is what I understand that securitization argument that you're making to be. But if you would like to address that, and then I'll hear from Mr. Melhorn in response.
Sure. Thank you. Thank you, Your Honor. So I prepared like an opening statement, if you will. May I read it?
Sure.
Okay, thank you. Defendant requests this court rule in favor of defendant's motion for summary judgment on plaintiff's lack of standing submitted February 19th, 2026. The motion that I submitted raises the threshold issue of standing, and during all these months has been undisputed by the plaintiff. Plaintiff has not produced a contract, any assignment, or any admissible evidence showing that they own this specific account. They have not proved or even attempted to prove that they own the debt, that I owe them the debt. And just for the record, I deny I owe Bank of America the alleged debt. Under OCGA 91117, they must prove they are the real party in interest. They have not met that burden, and they have not disputed summary judgment. It's undisputed, all the facts in that judgment that you've looked at. So defendant, myself, I request immediate dismissal. Thank you.
Thank you. Anything else, Ms. Smart?
I can.
I don't
No.
mean to imply there should be something else. I just always want to make sure that I've given you the opportunity to say what you want to say.
Yes.
And then I would hear from Mr. Melhorn, and then as you saw with the hearing I had a moment ago, it's your motion, so I would give you the
Yes.
opportunity to respond.
Okay, well, thank you very much. Do I object, or do I just wait until what's the proper way to do this?
So this is a legal argument. So really, you get to say your piece, and then Mr. Melhorn gets to say his piece without interruption.
Okay.
Sometimes you'll see more objections in the context of, where we have witnesses. Here, I would typically encourage people, look, if he says something that you definitely want to respond to, just make a note of it, and you'd be given a chance to respond. Typically, don't interrupt when they're making argument, just as Mr. Melhorn has not interrupted while you were making argument. So
Sure. Thank you for clarifying that for me, Judge.
thank you. Mr. Melhorn, your response, sir.
Yes, good morning, Judge.
Good morning.
So going in order, I guess, of Ms. Smart's argument, then I'll go in order of the allegations of the MSJ. To briefly touch on these issues, just to try to respond. So Ms. Smart brings up the issue of standing from Bank of America, stating that Bank of America is not that Bank of America has no standing to bring this. She also alleges in her summary judgment and prior pleadings that she was looking for the contract with the attorney firm. So there's an issue of, and I'm not sure if she's bleeding this together in her MSJ, but I want to address both for clarity before the court. Bank of America does have standing. We would object to her point that we don't have standing, as Bank of America originated this account. She originated this account with Bank of America. That's clearly proven on the statements that were provided on our complaint. These are original creditor statements from Bank of America to Ms. Smart at the address in which she was served, at the address in which I believe she's still living, because it's the address on her pleadings as the contact address. So these were sent to her from Bank of America, showing use, showing payments, as there was a payment attached to our complaint. I believe it was 3/26/2025 was the last payment. So fairly recently, a payment on the account. As shown in our complaint, the suit is between Bank of America and Ms. Smart. There's not my firm, Lloyd McDaniel, on behalf of Bank of America, stepping in as any kind of assignee or any kind of party in interest, other than we represent Bank of America as their attorney. As Ms. Smart can hire an attorney, we can hire an attorney. Very simple. So if she's looking for a contract between the attorney firm and the bank, we're not required to provide that, as that's not something we would normally provide.
Isn't that, I thought I saw some discovery that was served on you guys, but
right. And we answered
as I understand
the
the basis of the motion, it really is, here is, these assertions of fact that she believes are not in dispute about whether Bank of America owns the debt. Obviously, Bank of America has asserted that it owns the debt in the complaint, but I'm not certain. That sounds to me like a discovery issue that isn't really before me today. What's before me is the summary judgment motion.
I just wanted to, in case that was before the court, because it was in her original motion, because it was in her original answer, presenting it here. Now, moving on to the standing issue, she has stated in her motion for summary judgment and her opening statement that we do not have standing. It's not owed nor owned by Bank of America, and we must prove that we're the real party in interest. She brings up the issue of securitization, saying we lack standing. We must prove chain of title. So, with the issue of securitization, it's not legally relevant to any elements that plaintiff must prove in this case. In a credit card collection case, under Georgia law, the bank need only establish that we have an existence of any kind of interaction or agreement with the defendant's use of the account, the extension of credit, and the defendant's failure to repay the balance owed. We have done that. We have shown that she had used the account. She had actually made payments and purchases on the account. The statements were sent to her at her address. She did not dispute this. This is not in her motion for summary judgment or her answer raising any kind of issue of fraud, any kind of issue of identity theft. She's simply saying she doesn't know it because of whether standing or whether issues of documents not provided, but not disputing the actual charges, not disputing any kind of credit that was issued to her, purely that we do not have standing. We've proven this through the account records, the billing statements, and affidavits of indebtedness. Whether this receivable, if this is considered a receivable, was later pooled, assigned, or securitized does not alter the defendant's underlying obligation. She still has to repay the charges incurred. So if there was a trust, Bank of America transferred to some kind of trust, she would still owe the money to Bank of America, whether it was Bank of America or Bank of America Trust. The money is still owed. Therefore, any questions or accusations of securitization fall outside of any kind of scope of relevant evidence before this court or relevant arguments before this court. Bank of America has standing regardless of any kind of issue of securitization. Even if sold or assigned into a trust, originating banks have retained the rights to collect on an account that originated with the bank. Under OCGA of 9-11-17, Part A, real parties in interest, including an assignee or party with legal title, are allowed to enforce collection on a debt. Plain and simple. Conversely, defendant lacks standing to challenge internal assignments absent showing that the transfer affects the debtor's obligation. She has not shown that. She has simply said that there's some kind of issue of securitization. She's poking things in the air saying there's an issue of securitization. I know Bank of America has transferred this to a trust, but she's not saying this relates to her debt in any kind of way. It hasn't changed the obligation to repay. It hasn't changed the amount. The amount that was mailed to her in her charge-off statement and the ongoing statements that were mailed to her address remain the amount that we sued for. This is not a secured debt anyway. Credit cards are unsecured. We can't supplant mortgage or security instrument arguments of securitization for a non-secured account or non-secured debt. Georgia courts reject attempts routinely from consumers to import mortgage-based securitization defenses when there's no property of interest or chain of title issues requiring such scrutiny. We haven't gotten there yet, Your Honor. I don't think we're going to get there. It's a simple unsecured credit card debt. Furthermore, gently touching on this issue, as I know discovery is not before this court, but any kind of issue of securitization that Ms. Smart is trying to gain evidence or propose that there's a lack of evidence or a lack of response from plaintiff on this issue is unduly burdensome and disproportionate and confidential. This is not a document that relates to her. It would not show her debt as it would with any kind of debt buyer saying, hey, I bought your account and now I own it and now I'm the right party in interest. That doesn't happen with any kind of securitization that I'm aware of, but I'm not privy to any securitization, but it's not a debt buyer. Plain and simple. Bank of America sent the statements. She had the credit with Bank of America. Bank of America is suing her. This is complex documents that involve no bearing on the individual account.
Again, Mr. Melhorn, I apologize. I understand you want to make a
Yes.
record, but
Okay.
this is not a discovery hearing. And if it was, the court would be having an informal discovery conference where you would get an opportunity to make these arguments. But we're
Okay.
not here on that. No one has asked me to compel any responses. No one has argued that the responses are insufficient. No one has asked me to protect them from having to respond. It's just not an issue that we are here on yet. Where we are is a summary judgment that was filed by the defendant in this case, which I'm sure, I mean, look, I do a ton of these credit card cases, right? And what most often happens is the defendant doesn't answer at all and the credit card company gets a default judgment. Or when the defendant does actually answer, then we end up with some sort of summary judgment based on the documents that are but usually it's in favor of the credit card company. And so I understand that we are a little outside of sort of the standard pattern and practice of what happens in these cases. But nonetheless, Ms. Smart has filed a procedurally sufficient, right, under 9/11/56 summary judgment motion, and it was set for hearing, and now we're all here. So go ahead, unless you have anything to add regarding the summary judgment motion standard. I don't know that we need to discuss the discovery matter.
That's fine, Your Honor. And again, I was only, just for clarity, I'm not trying to, upset the court or make this outside of the scope of the summary judgment. Ms. Smart had mentioned that we didn't provide sufficient documentation.
Mm-hmm.
That's where I was going with that.
Okay.
So moving on, there is.
Hang on, forgive me, Mr. Melhorn.
Mhm.
To be clear, my understanding at its most basic is that although the complaint has attached to it credit card statements, I think her main argument is you didn't provide an original credit card agreement document, like some
Sure.
sort of, here's when I got this credit card 12 years ago, and here's my signature saying I agree to be responsible for it. That's what I understood her argument to be, not larger issues associated with this securitization claim.
Sure. And I will touch on that right now, Your Honor. So Ms. Smart in her MSJ says that she brings up to maintain, there's a part where it's quoted, to maintain an action for a breach of contract, and it goes on to the standards of breach of contract. We're not pursuing collection on a debt based on breach of contract. We pursued the debt under a open account, basically a account stated provision theory of law, and suits on open account are simplified pleadings where a party can recover what he was justly and equitably entitled to. And I'm quoting the Advanced Tuffing Inc. versus Dane Shiar case. I can give you that site if you want. It's a 2003 case, but essentially the balance due with an account, an open account or an account stated, is proved by supporting documents as secondary evidence, such as the last statement, demand for payment, introducing into the evidence as a business record. We have done that. There was a last payment statement attached. There was the charge-off statement attached showing the balance that we are pursuing. As such, we have submitted a prima facie case for the sum sued and owing to the plaintiff. Burden has shifted to Ms. Smart to say that that's not correct. She has proceeded with the summary judgment. There is a genuine issue of fact here that precludes her summary judgment. We have proven our prima facie case. She has not disproved that the balance is not owed. She has cited, as I stated, securitization, standing, and the standard for breach of contract, which would not apply simply in this case, as we did not pursue a breach of contract. With that said, Your Honor, I think plaintiff has shown pretty clearly that there are, one, issues of material fact here, two, that the allegations from Mrs. Smart's MSJ are not pertinent to what is before the court today in this motion for summary judgment, and greater, what this complaint alleges. And therefore, I believe Ms. Smart's MSJ should be dismissed.
Understood. Thank you, Mr. Melhorn. Ms. Smart,
Thank
as
you.
I mentioned, it's your motion, so you get the last word, ma'am.
No, thank you, ma'am, Judge. So I understood, first of all, I object to the attorney because everything pretty much he said was hearsay and lack of foundation. There's no proper witnesses, no qualified witness to even
So Mr.
corroborate.
Melhorn, I'm going to overrule that objection. Mr. Melhorn is an attorney who's making argument based on what he believes are either the allegations of the pleadings or facts that he believes are in dispute. And he's allowed to do that. He's not a witness. He's, as I said, simply making argument based on the facts and laws he understands them to be in this case. So that's my ruling on your objection. Go ahead.
Thank you. Well, I'm going to get back to the case of standing. If there's no proof of ownership of the claim, regardless of where it started, there's no assignment, then there's lack of standing, which is which places the burden back on the plaintiff to show that, because they're the ones that brought the suit against me. So records show there's, let me see, just move towards my notes here. So they had several months to provide evidence through the discovery and also to respond to the undisputed summary judgment. They did not do that. And standing is a threshold issue. If Bank of America loses standing, which I believe they have, and they don't have standing, then the entire case has to be dismissed based on my research and my understanding. There's been no evidence presented today that they currently own the debt and that they owned it at the time of filing the lawsuit. And that is totally an issue of standing. I mean, Exhibit 2, obviously, they brought up the securitization. You know, that's not a major portion of my argument anyways, but it basically shows that they sold the debt and that they no longer own it. So to me, that just makes it even a stronger argument that they are not, they do not have standing. There is no contract that's been presented. Statements are not facts of ownership, and they've provided no evidence as such. And based on my research, again, Bank of America is not the true party in interest. And I don't know what he brought up about secured and unsecured debt, but I'm not even going to go there with that because I really didn't understand what that had to do with the case today. I'm just a pro se kind of gal. But it just gets back to evidence of ownership. They haven't proven they own the debt. They haven't proved that I owe the debt. And I deny that I owe Bank of America any debt, alleged debt, I should say. Let me see if I've left anything out. Just without proof of ownership and admissible evidence, they cannot establish standing. Therefore, the case, I believe, must be dismissed with prejudice as per my motion of summary judgment. Let's see, plaintiff, I guess I can bring up OCGA 911-17, which says plaintiff must prove, since they are the moving party, that they own the specific debt, and they have not done that. So again, it comes back to no proof of ownership for the plaintiff and no admissible evidence. So therefore, they cannot establish standing.
Okay. Thank you, Ms. Smart.
Thank you. Yeah, I know I kind of went on there, but I apologize.
No, I
Mr.
thought both of you
Pro-Se.
were remarkably efficient with your presentation. So I was not faulting you in that regard.
Thank you.
So here's where, as I mentioned, you know, I deal with these cases all the time. They are almost always handled as defaults or as summary judgments because they are fairly straightforward. Although, as I said, this is a bit of a unique situation because we have a summary judgment that was filed by the defendant debtor here, alleged debtor, I should say, in
Thank
fairness
you.
to Ms. Smart. But here's where we are. So in terms of how I handle these cases, right, once they are filed, I tell the parties, hey, I'm going to enter a scheduling order. And that will provide the parties with an opportunity to engage in any discovery that's necessary And hey, if you think you need longer to do it than I give you, then you tell me. And I told you what I was going to do, and nobody objected. And so I entered a very expedited discovery schedule. I do believe that there was some discovery that was served, but again, no one has asked me to compel responses to that discovery or otherwise raised those as issues other than Ms. Smart's argument that Bank of America has not come forward with documentation to refute the asserted facts that are undisputed in her summary judgment motion. And I think where this really falls for me is Ms. Smart's characterization of the obligation of the defendant to come forward with that a party may not rest upon mere allegations or denials, but must respond by affidavit or otherwise, setting forth specific facts that show there is a genuine issue for trial. I agree that is the obligation on a non-moving party, but that obligation only arises under 91156C if the party, the moving party, Ms. Smart, has come forward and demonstrated that there is no genuine issue of any material fact and that the moving party is entitled to judgment as a matter of law. And I don't believe that Ms. Smart's motion has satisfied the requirement, the threshold showing of 91156C, such that Bank of America was required to come forward with specific affidavit testimony under 91156E. And so because of that, I'm going to deny the summary judgment motion. Now, that doesn't mean that this case is over or that Bank of America is entitled to recoup on its debt. At the beginning of this hearing, Mr. Melhorn asked about these other hearing dates, and that's because this case is on a trial calendar. And so on May the 7th, you guys will be back here and we will be talking about, I expect to see a consolidated pretrial order. Y'all can tell me if you want a jury trial or if we're going to try this as a bench trial just to me. And then if the matter needs to be tried, whether it's a bench trial or a jury trial, then the parties would be called in the week of. I don't think it's actually specifically the date of May the 25th. It's typically the week of May the 25th, which actually, I think, if I'm remembering correctly, I think May the 25th is Memorial Day. So it's actually Tuesday the 26th. And, you know, what I expect will happen is that we will, on May the 7th, have a discussion about whether this matter can be resolved. And if not, how long the parties think it will take and what witnesses and exhibits the parties think they will offer on this issue. And then if the case does not resolve after that, then sometime around May 26th or shortly thereafter, we will have a trial. Whether it's a jury trial or a bench trial is up to the parties in terms of whether one has been requested. I don't know. But that's what's going to happen next. My intention is to enter a very brief order on the summary judgment motion. I'll draft it myself. That basically outlines in a couple of paragraphs the basis for the court's denial of the summary judgment motion. And then I would see the parties again on, as I said, on May the 7th. Understand that, Ms. Smart, you're probably not happy with the court's ruling, but understand that is going to be the court's ruling. Do you have any questions about the procedure that will happen next and what next steps or what is expected?
Yes, thank you, Your Honor. And yes, I'm not happy with the judgment. I did have a question. You were calling me the moving party, I thought. I need
Yes.
a clarification around that. How am I the moving party when Bank of America is the one that filed the complaint?
Because you filed the motion for summary judgment that I was considering. And so when there's a motion, the moving party is the person who filed the motion. That's
Okay.
not the same as the party who's seeking relief in this case, which is Bank of America.
Okay. And you said it was a pre-trial. Just where can I find out information about what to be prepared for other than what you've mentioned today?
So I don't know if you have corresponded with my staff attorney, but
have.
every email he sends out, and I think every notice that we send out includes a link to the court standing order and the
Yeah.
template that the court uses and expects the parties to use for a pretrial order.
Okay.
And so that should provide you with some guidance regarding what the court expects to occur on May the 7th.
Okay, and if you may, or if I'm asking, if you can, just in a sentence or two, please help summarize why you're not agreeing with my summary judgment. I guess I just don't understand what it was lacking, what the miss was. Are you able to do that for me?
I mean, I can repeat what I've said. I'm not sure. I mean, the issue, Ms. Smart, is unfortunately people come into court and they are not represented by counsel. And the law is pretty clear that I'm not allowed to give you legal advice, and I'm not allowed to give you any greater consideration because you don't have a lawyer.
Yes.
What I'm telling you is that Georgia law, OCGA 91156, provides the structure that the court is supposed to apply in considering summary judgment motions. And OCGA 91156C says that the party who is moving for summary judgment must show that there is no genuine issue as to any material fact, and that the moving party is entitled to judgment as a matter of law. And my ruling is that I believe that there are genuine issues of material fact, and that even if there were not genuine disputed issues of material fact, that the defendant, you in this case, are not entitled to judgment as a matter of law. Now, you might be entitled to a judgment later as a matter of fact, but I don't believe that you are entitled to judgment as a matter of law. And so that's why I've denied your summary judgment motion.
Thank you.
Anything else, Ms. Smart?
No, I'll have to research all that, but thank you.
Okay. Mr. Melhorn, any questions, sir?
Just to be sure, Your Honor, it looks like dispositive motions were ended on April the 6th, correct?
That's correct.
Okay, and I'm looking right now, we had filed a summary judgment ourselves, it looks like on the 1st, but I don't show an envelope and I'm not showing it on Odyssey. So I don't know if that ever made its way to you. April.
I never received
Yeah,
anything.
I don't. Hey,
Yeah,
Ms. Smart.
okay.
So y'all don't talk to each other. Y'all talk to me.
All right.
And Mr. Melhorn, I'm not sure if there was an effort, you're representing to me that there was in your office, but I can assure you that I'm looking at my docket and there is nothing filed by your office as a summary judgment motion. The only filing I have is Ms. Smart's summary judgment motion. And then once it was ripe, we entered a notice of hearing, and then that matter was continued. And then it was continued to today. We set it for hearing, and then we also issued a notice of trial based on this scheduling order. So what I always tell people is that if you file an untimely motion for summary judgment, congratulations, you have a DV motion, right? I mean, that's just, that's how it will go. I'm not going to consider summary judgment motions that are filed out of time. So if you file it now, it will be in the record, but I'm not going to hear it pre-trial.
Right.
And so we will figure out what issues there are for trial and how long it will take to try this case and whether it's going to be to a jury or to me, and we will do that on May the 7th. Any other questions,
Okay.
Mr. Melhorn?
No, Your Honor, and that was a point of clarity. Just to make sure it wasn't, for whatever reason, sitting on somebody's desk or anything to ask any kind of question or anything, because I didn't see it in Odyssey either. I see it leaving my office. I don't show an envelope number, so I didn't know how it was sent out, whether it was trying to e-file or mail for some reason. Just trying to clarify that issue, and that's fine. We'll move forward with trial and get you a pretrial notice or pretrial order as soon as possible.
Okay. I do want to make sure, Mr. Melhorn, you did indicate that you did not have a record of having received Ms. Smart's motion for summary judgment. I do want to just remind you that it is, and I don't mean this as a slight in any way, but a lot of these cases that are the practices are high volume practices like credit cards, like HOA fee type. I see this a lot where it is sometimes the firm is not doing as good a job as perhaps they should be of making sure that these notices are received, captured, and then routed to the lawyer whose responsibility it is to do something about it. But ultimately, the law is pretty clear that it is the party's obligation to make sure that they are properly registered in the e-file system, so that they're receiving notices. And everything in my system at least says that Mr. Freehoff could probably hop on here and tell me exactly to whom it was addressed, but at least I know generally everything in my system is that a service notification was generated when it was filed, and that someone associated with the plaintiff's law firm received notice of that filing. So that's all I got.
That's fine, Your Honor, and that's fine. I appreciate the time that you gave me to, review it. At the very least, that was very appreciated, so I could enumerate some arguments rather than being all over the place. I do see there we have a few lawyers who are still with the firm, listed as the attorneys of record in Odyssey. For whatever reason, I just didn't see it in the system. So apologies for that, Your Honor.
No worries. Now, in the interim, I will say, Ms. Smart, I understand that you dispute this debt. Obviously, Mr. Melhorn, I understand that your client is like, no, this debt is this debt, and we are seeking to recover it. But I will say that oftentimes I do find that people in Ms. Smart's position have a difficult time negotiating anything with Bank of America, because nobody ever knows who to not Bank of America, but credit card companies generally. And that at least now there is an actual lawyer involved. To the extent that y'all are able to engage in respectful and civil communications, perhaps by email, about the possibility of resolution. If resolution can't be had, it can't be had. I understand that. But if it can, it is May the 1st. You've got 6 days between now and May the 7th. And y'all are going to have to be in touch, because if you're properly doing what you're supposed to do, you're going to be talking about a consolidated pretrial order. I really encourage the parties to talk about whether there is any possibility of resolution, because that is one of the factors that you'll need to report to the court on May the 7th, is whether the possibility of settlement is fair, good, etc. I do encourage the parties to really engage in that effort. And that way, look, when you tell me there's no chance of resolving the case on May the 7th, then that's fine. And we'll make arrangements to be available for the parties to try the case. Okay.
Sounds good, Your Honor. Ms. Smart, may I get your email? Was that okay?
Sure. Yes. It should be in the e-filing information, no? On the court.
I'm
I'm
looking
happy
right
to give it
now.
to you now. I don't, yeah.
Yeah, I'm looking right now and I just don't see it. But
Okay,
if you can
sure.
give it to me, that'd probably be sufficient.
Tracy, Tracy,
Mhm.
Smart, Smart, Sweet, Sweet, Tracy
Mhm.
Smart Sweet at Gmail.
All right, I've got it.
And, will you send me your contact
Yeah,
information?
Mr. Melhorn, can
Of
you
course.
tell her your email address as well, please?
Yes. Do you want me to just email you, Ms. Smart? That way we can start an email chain?
That would be great. Thank you.
Okay.
And
I'll do
I
that
think
right now.
that we are in touch in terms of, if anybody's ever been in touch with us, Mr. Freehoff is very good about, hey, we're not going to have any ex parte communication and copying anybody else. So, like I said, I would just encourage you to continue to engage in any efforts to resolve the case. And other than that, I will see you on May the 7th. Okay.
Sounds good, Your Honor. Thank you so much.
Can I ask a quick question?
Yes, Ms. Smart.
Thank you. Will I receive something through the court, e-filing for this consolidated pretrial order, or?
You already did
May
on
7th?
April the 20th. The court, Mr. Freehoff filed a notice of placement on the 5/25/26 trial calendar.
Yes,
And a notice of May 7th, 2026 pretrial conference.
yeah,
And that's one of those types of documents that I was mentioning, that if you received it, it's got a link in it to the court's preferred pretrial template. And frankly, if you just Google Judge Rachel Krause, I think the first hit is the court's website. And there's a page that I have that has templates, links to templates that the court has for both its preferred procedures and also its preferred form for a consolidated pretrial order.
very good. Thank you very much.